right, welcome back to Law and Crime Live. That was a replay of the defense's closing arguments earlier today in the case of Florida versus Brian Hyde. He's accused of killing 3 of his relatives, one of which was an unborn child. Hyde took the stand yesterday, only on very short amount of time, about 15 minutes total. And he stated that he doesn't remember whether or not he committed these murders. We are going to show you a clip of that in a little bit. But just before we do, I also want to mention that we are on verdict watch in the case of Tex McIver out of Georgia. Remember, McIver is accused of killing his wife, Diane. His defense is that it was a mistake. He claimed the gun went off accidentally when he was sitting in the back seat of his SUV. Now, the jury has now been deliberating for over 15 hours. And yesterday they went back to that SUV, this time with the gun. Several of the jurors took turns sitting in the back seat holding the gun. They started the day out by re-watching Tex's police interview. And deliberations have continued starting this morning at 9 a.m. And they've been told by the judge that if they don't come to a conclusion by 4 p.m., that they will have to break if there's no verdict. I'm joined, luckily, to break it all down in studio with Imran Ansari. He's a criminal defense attorney and former prosecutor. Imran, thank you for being here.
Oh, it's great. Thank you. I'm happy to be here this afternoon.
Thanks. Okay, so the case of Tex McIver, this has been occupying our lives for the past couple of weeks. Of course, trial went on a break for a little bit, so we had, it seems like we've been covering this case for many, many weeks. What do you take it as a criminal defense attorney, and we can talk about this, that the jury has already been deliberating for, many, many hours at this point?
Sure. You have a thinking jury, and that's clear that they're taking the evidence, they're evaluating the evidence, they're taking their role very seriously. They've been deliberating since earlier this week. You hear that they went back to the car. They've been handling the gun within the car. So this jury really wants to put themselves in the position of Tex McIver so they can evaluate the evidence, put themselves in his shoes in some respect, and see, does the evidence add up? Does the evidence prove the case beyond a reasonable doubt? So they're really taking their job seriously. They've been deliberating a long time. We really don't know what's going on in that jury room, but we do know that there may be differing opinions, and some jurors want to put themselves in his shoes, feel that sort of the evidence in their hands, put themselves within that car, and see for themselves how the evidence adds up.
Yeah, now, it's always kind of a dangerous game to play to sort of read the tea leaves as a defense attorney in terms of what the jury is asking. But the jurors ask some pretty interesting questions over the course of their deliberations. What do you make of those sort of, them telegraphing kind of where they're going from what they've asked so far?
Sure. Well, from my personal experience during trial, you get those notes from the jury. They have questions. The judge may read back some evidence, some testimony. They may want to see some of the exhibits. But you can never really put yourself in that room. A lot of times you get these notes from the jury. They have questions, and they're looking through the evidence. They're thinking. But the result, you try to think, all right, let me see if I can read the tea leaves, as you say, and see what this jury is thinking, what direction they're going. But a lot of times when you get that verdict, it's really not what you thought. Juries are very dynamic. They're very, one day they could be going this way. Some evidence could sway them the other way the next day. So here you have, in this case, a jury that's clearly thinking, clearly evaluating the evidence. But you could really never tell from the questions that come from the jury, from the evidence that they want to see. It gets your mind racing as a trial attorney when you're in that courtroom and you get those questions from the jury. Oh, are they going this way? Am I going to lose this case? Am I going to win this case? But ultimately, at the end of the day, juries surprise attorneys all the time.
Yeah, I generally agree with that. I think in this case, the fact that the jury asked whether or not they could acquit him on the murder charges, but still find him guilty of the witness tampering, I got to say that as a defense attorney, I'm happy with that question because I think it gives you a little bit of insight into the juror's mind. I want to continue talking about this, but right now I promised viewers that we would show this kind of bombshell clip of the defendant in the case of Florida versus Brian Hyde taking the stand yesterday and stating that he doesn't remember whether or not he committed these murders. Take a look. All right, that was the testimony of Brian Hyde, the defendant in his own murder trial, taking the stand. I'm joined in studio with Imran Ansari, former prosecutor and current trial attorney. Imran, thank you for being here with us.
Thank you for having me.
I mean, we were talking a little bit off camera, but what do you make of having a defendant in a murder trial take the stand in his own defense?
Well, it's extremely rare, unless you're really going with a self-defense justification defense, which is an affirmative defense. A defendant taking the stand is pretty rare. The Fifth Amendment affords a defendant the right not to have to testify in a criminal trial in their defense. So many times you put the people to the burden, the prosecution to the burden, and the defendant will sit back and enjoys that sort of right to remain silent, so to say, right? Here we have Hyde taking the stand. He's testifying that he doesn't remember anything about the murder. So the defense made a strategic decision here to put Hyde on the stand. The prosecution has the right to cross-examine him, and it sort of opens the door. Everything is, fair game to the extent of what Hyde testifies on his direct. So you're really putting your client as a defense attorney, when you put them on the stand, you're opening the door to a lot of possibilities on cross. And either that defendant is going to hold up on the stand or they're going to be cross-examined by the prosecution. And now the silence that defendant could have enjoyed, so to say, is gone. So it's a risky maneuver on the part of a defense attorney, unless you have to really put your client on the stand when there's a self-defense, affirmative defense. But in this case, Caroline, there's no affirmative defense of that nature.
Yeah, I mean, I totally agree. And just to remind viewers, again, we are also on Verdict Watch in the case of Tex McIver, a defendant who chose not to take the stand in his own defense. We are going to be running through sort of the strengths and the weaknesses on the part of the state and where potentially their case could have holes. So I want to play a clip of the opening arguments in the case of the Tex McIver trial, which we are on Verdict Watch. Again, remember, Tex is accused of killing his wife, Diane, and his defense was that this gun discharged accidentally, that he was awoken from sleeping in the backseat of his car, and that the gun went off accidentally. Now, the thing about this case is that there is an underlying economic potential motive, and I want to talk to Imran about that a little bit. As a defense attorney, how far do you go in terms of planting seeds for, a potential defense in this case, in the face of, this evidence that we've heard about the potential financial motive?
Well, you're going to take the evidence, you're going to look at what the prosecution is going to be aiming to prove during their case. And here in the McIver trial, there's the motive which the prosecution is going for is that there was a financial motive for Tex McIver to murder his wife. So as a defense attorney, you're going to take that sort of theory of case that the prosecution is putting out there, and you're going to try to poke holes into that any way you can, whether that be on the cross-examination of the prosecution's witnesses or through evidence that you bring in on the defense case at trial. So this is the theory of case that the prosecution is putting forward, and the defense will have to work hard, and I think they have, to poke holes in that theory.
Absolutely. Let's take another look back at the prosecutor's opening statements in the case of Tex McIver. A verdict of guilty apparently is the only verdict that the prosecutors want the jury to return in the case of Tex McIver. Of course, we know that jurors have been deliberating now for quite some time in that case. I'm joined in studio with Imran Ansari, former prosecutor and criminal defense attorney. Imran, thanks for being with us. What do you make of the prosecutor's opening arguments? I mean, they really came out strong, but I personally have a sense that they kind of overpromised and really underdelivered. What do you think?
Right. I mean, we've come a long way since those opening statements in this trial. The prosecution, you never want to promise too much in opening statements. You always want to sort of keep it undertoned and not necessarily tell the jury that you're going to see this and that, because trial is dynamic. Trial changes as that trial progresses. The evidence comes in or it doesn't come in. testimony could go this way or it could go another way when it's on cross. So you never want to oversell your case or defense during opening statements. Especially as a prosecutor, when it's your burden, you don't want to oversell your case. So we've come a long way in this trial since those opening statements. They really were setting the stage, so to say, for the prosecution's theory of the case, painting Tex McIver to be someone who was motivated by greed, painting Tex McIver as someone who wanted to financially benefit by murdering his wife. So they, in this trial, really put it heavy in those opening statements. As we know, for those who've been following the trial, a lot of evidence has sort of dampened or that prosecution heavy opening. But again, the jury is really thinking in this case, and we'll see what happens.
Yeah, when I heard the prosecution's opening arguments, I have to say, I was thinking that they were going to present some sort of smoking gun evidence of this financial motive. And then, of course, they never got it over the goalpost in terms of we've heard all of this testimony about the question of whether or not Diane was actually in the process of revising her will and whether or not Tex would actually benefit from a sort of liquidity standpoint if Diane in fact died. I still don't really know the answer to that question. Do you feel like you have a good answer to that question after we've heard all of this evidence in this case?
You know what? I believe that the prosecution, again, laid that out in their opening statements. They sort of painted that as their theory of the case. And I agree with you, Caroline. I don't think the evidence has necessarily proved that sort of motive yet, right? So now you have the jury thinking about this case and actually thinking more about the forensics and how that gun went off. We know that the jury has been handling the gun. They've gone to the car. But to get back to your question, the prosecution came out with that financial motive as the theory of their case and behind this murder. They put evidence out there, but I don't feel like they've really come a long way in proving that theory.
Right. Well, let's take a listen to the defense's closing arguments, and then we can break it down a little bit on the flip side. Take a listen. All right. We just heard two of the key takeaways of the 5 takeaways in the defense's opening statements. They're trying to defend the Claude Tex McIver trial, saying this was an accident. The gun went off. Just to clarify, she stated it wasn't an accident in that we're admitting that Mr. McIver actually pulled the trigger, but it was an accident. And one of the first 2 reasons she said there that the gun was resting in his lap at the time it was discharged, and it was fired from a sideways position. So, Imran, I'm here on set with Imran Ansari. I just want to talk to you a little bit about the forensics in this case and how important they are to both the defense's argument that it was accidental. What do you think are the key takeaways of the forensics here?
Sure. The forensic evidence in this case regarding that gun it's huge, right? So it's, I think, the prosecution's biggest problem in this case. So you heard in the opening statements of the defense that the gun had 2 sort of modes. You had double action, you had single action. And there's a significant difference in the amount of pressure that is needed for that trigger to be pulled, whether it's in single action or double action, right? So I think it was 12 pounds of pressure for double action and then less for single action. The forensic evidence can't conclude with certainty what mode that gun was in when it was fired by Tex McIver and it struck his wife. So that's a big problem for the prosecution, because if it, significant amount of pressure on that trigger in one mode would go to prove some evidence to suggest that that was an intentional firing of that gun, because it would require strong pressure on that trigger for that gun to be fired. Whereas in the other mode, it would require significantly less pressure for that trigger to be pulled. So the experts in this case, the expert for the prosecution, cannot say definitively what mode that gun was in. So that's a big, beyond a reasonable doubt sort of argument for the defense. They can suggest to the jury that the prosecution has not proven that that gun was intentionally fired based on that forensic is a big uncertainty in this case. It's a big problem for the prosecution. And what I think is very interesting, Caroline, and a very interesting anecdote about this trial is that when the prosecution's expert was handling that gun on the stand, it went off. So, of course, it wasn't loaded, God forbid, but the trigger went off, right? And that wasn't on purpose. It was an accidental trigger going off on that gun. So the prosecution was handling that gun, and it accidentally went off. If I was the defense attorney, I would be jumping all over that in my summations, because that's basically the defense right there. Look, this gun is prone to accidentally going off. And you saw it right there on the stand, ladies and gentlemen.
I'm so glad you brought that up, because if you didn't, I was going to. Because, yes, I agree. We were all here at the network. We were kind of jumping out of our seats when this bombshell moment happened. A state's, their own witness got up on the stand, and he was showing the gun. He said, oops, and it discharged. I mean, that you don't get, as a defense attorney, that's just sort of a gift from heaven. So I agree that's a huge win for them.
Right, and I would not want to be the prosecution at that moment. When you're in trial and you have a witness on the stand, you're sort of hanging onto your seat with each question, especially on cross or each answer, because as much as you prep a witness, sometimes when they're on the stand, things don't go the way that you planned, right? That's just the nature of trial. Like I said before, it's dynamic. So I would not want to be the prosecutor when that moment happened, when they had their expert on the stand and that gun accidentally went off. Their heart must have dropped. I could feel the sort of sweat forming on the brow at that moment. So that was not a good time for the prosecution, I would imagine.
Right. Well, that's what happens, ladies and gentlemen, when you cover live trials. Things happen that you don't necessarily suspect. That's why we're covering everything for you live. I also want to bring up the point, and we've had forensic death analyst Joseph Scott Morgan on to talk a little bit about, and I don't know if we have that picture we can show of the gun with the red line, the forensic analysis that they showed. But basically, I felt it was pretty strong evidence that this gun was discharged at an angle, right? It was kind of lying on his lap. We saw the defense opening statement there. We saw, yep, there it is. We saw the attorney sort of do a reenactment there in her opening statement about the way in which this gun went off, because having to do with the length of Tex McIver's forearm and sort of the constricted nature of the backseat of the car. Now, if you were planning on killing your wife, would you do it on a side angle shot?
Well, there's a disclaimer here to my wife who may be watching. This is all hypothetical.
Yes,
right?
Of course.
So, no, I mean, the forensics in this case, may make or break it for the prosecution, and it may be the source of a acquittal for the defense. So I think, that's very telling, the fact that the trajectory was at an angle, because you can imagine, what do you think about if someone is intentionally looking to shoot someone? In your mind, you think, all right, you're raising your arm and you're aiming that gun at that person's head. That would, in this case, right? So here, the trajectory, the forensics show that it was at an angle, which goes to suggest and help the defense's argument in this matter that Tex McIver had that gun sort of on his lap. It accidentally went off, and the trajectory didn't go from extended arm into the back of the head, but rather from a resting position on his lap upwards into his wife. Yeah. So it really supports the defense's argument that this was an accidental shooting. And I think the forensics in this case, with the gun, with the trajectory of the bullet, are really going to be key factors that the defense, that the jury is considering here. And we know that because they're in the back of that car, they're holding the gun, and they're seeing for themselves, sitting in the back of that car, how the gun feels, how the space and the distance is between the back seat and the front seat, and they're getting a firsthand sort of look for themselves into the evidence there.
Yeah, really good point. I just want to bring up, so that was one of the questions that the jurors asked the judge if they could in fact go to the SUV, really handle the gun to see what it was like back there. And I think that's a really good demonstrative, way for jurors to really put themselves in the place. I also want to read the other questions, that I was alluding to before, that the jurors asked the judge. They asked whether or not McIver could be found not guilty on counts 1 through 4, but guilty on count 5. Now, counts 1 through 4 are malice murder, felony murder, aggravated assault, and possession of a weapon in the commission of a felony. Those are obviously the most serious of the crimes. And count 5, which is less serious, is the witness intimidation charge. That's a pretty good indication, I'd say, if you're a defense attorney in this case, where you think the jurors' minds are going. But that was a while ago at this point, and they've still been deliberating. I want to show the rest of the defense's opening statements, and then we can talk about it on the flip side.